Hey, Attorney Brian Parker here. Time for another exciting video. This one comes from a viewer of my YouTube video, my YouTube channel, which I put into my membership website. But with the membership website, I add all the templates and the documents and my show notes so you can do a better job, not just what you hear from me, and hopefully that helps you. But the membership website, collectionstoppersolutions.com, is where you go for the important defense and motions and discovery and requests to produce and everything you need to litigate a case on your own. It's the one-stop shop for represented and non-represented victims of debt collection. So the person that contacted me had seen my previous video, which was treat arbitration like the plague. And I was saying, don't go to arbitration, do whatever you can, because it's just not fair compared to the rights that you have in court. It's unfair cost. There's an arbitrator is sometimes not an attorney or not even from the area that you live in, whereas the judge, it could be your neighbor. There's no rules of evidence or ability to protect you under the court rules or give you due process. It's an arbitrator. So expect arbitrary rulings, meaning whims, feelings, non-factual assertions and holdings, as opposed to if you're in court, there's the law, there are the rules. You can get some stuff in, you can't get other stuff. In fact, the basis of all our cases is use their documents against them. You may not be able to do that, probably not the way you want to, and they can bring stuff in against the rules of evidence because the rules of evidence don't exist. And then the worst thing is, whereas a lawsuit takes a year, you can get a judgment against you that you feel is arbitrary and the case is gone, it's been dismissed. So now you got a judgment against you in a couple of months. So I said, don't do it. Get it, treat it like the plague. I also reviewed a solo suit video. That's a company that offers you answers with no discernible reason or fact or support behind what they give you, and they charge you. And they had done a video after that video telling people, hey, come and use our answer that says, go to arbitration, stay out of court, which doesn't make any sense to me because why, if your main thing is selling answers, why would you tell people to go to arbitration? So I've done those two things, and the viewer said, hello, I was wondering if you have any video suggestions or ideas if you are forced to go to arbitration. Thanks. The reason I say forced is because if I didn't object to arbitration, it would have gone straight there. However, because I objected to it, I was granted a hearing in front of the judge and explained why I didn't want to go to arbitration thanks to your videos. But unfortunately, the judge basically said, that's not how it's done here. The amount is too low and you have to go to arbitration. There is no, hey, the amount is too low reason, provision, basis for going to arbitration. It isn't even in the arbitration rules that this guy said require you go to arbitration. So that guy just wanted stuff off his docket, and I warned about that. And you can see my video, how to handle judges. Shoom. And here's my video on how to treat arbitration like the plague. There it is, gone. And also there's my solo suit review video. There it is. And that should be gone. Again, that's all on my membership website with all the templates and forms you need. So the judge said I could object to the outcome if I don't like it after arbitration. Well, why can't you object to arbitration so you don't have to go through that charade? But I digress. So what do you do? Because the name of this video is show notes for what to do if you're forced into arbitration. So let's take a look at this. If you like this video, love this video, please subscribe, click on, just keep us rocking. So I'm now going to give you what you can do. And I want you to remember, as I've counseled you in other videos, be your inner problem Parker. It always helps you if you are a problem. Judges don't like problem litigants. They may yell at you and scream at you, but they prefer to have you away. attorneys, collection attorneys can't stand educated, unrepresented, but smart and problems because they face the possibility of losing because they lift 20-pound weights all day, right? Because they're just victimizing people. You are lifting 100 pounds. Your case against you. So they know that. They don't want any problems. They chose that job so there'd be no problems so they can just roll right over people. So be a problem parker, right? I've made a nice living and kept a roof over my kid's head from being a problem parker. So let's first look, and this is going to be boring, but it isn't, trust me. The Supreme Court, it used to be the Supreme Court said everything goes to arbitration. There's these huge class action cases which are clearly the right way to go for consumers. And the Supreme Court came in and said, nah, gone. Now they just ruled the other way with two cases. One is Smith versus Pizzeri, and that we'll put it up there. That's a 2024 case. And the importance of that case is what happened, and it happened to me, is they file a motion to compel arbitration because I was obviously doing something they didn't like and they fear they were going to lose. So they go, whoop, let's go to arbitration. And then the court says, yeah, you should go to arbitration. Get it off my docket. Case dismissed because I get it off my docket. So the Supreme Court has now ruled, no, you can only stay a case when it goes to arbitration. There's no rule under what's called the Federal Arbitration Act. Most arbitration cases go under what's called the Federal Arbitration Act. And it is sort of draconian in that it doesn't give you a tenth of what you receive in court as far as your rights and protections. But they have to put up a good face, so there are some rights and protections in there for you. But the Supreme Court said, there's no rule in the Arbitration Act. You have to understand, people get mad at Republican judges, okay? I don't. Because Republican judges, by and large, will go, if it's in the rules, if it's in the statute, I'll agree to it. Generally, you can go to what's called defendant courts, and the rules will say one thing, but the judge will go, yeah, but you got to be nice, so you got to do this, and it's nah, blah, blah, blah. And if it happened to me, I wouldn't like. That's not the rule. Republicans go, no, here's the rule. We got to live by that, and that's what you have with the Supreme Court right now. They may not even like this decision because it helps consumers. They don't automatically get their case dismissed. But those are the rules, and that's why you got to like Republican judges. That's just my opinion. I'm not saying I'm Republican or Democrat or anything. I say I like, in law school, know the procedure, know the law, know your judge if you want to win. So, and I counseled you. Sometimes I'll go deep on a judge to see what he likes. If he likes lemons, I'll wear a lemon tie, whatever it takes. So that's where I'm coming from. So the court held that the plain text of the FAA, the Federal Arbitration Act, requires a court to stay a proceeding and overrides any discretion a district court has. So that's sort of a slap in the face of a democratic court, if you will, because again, to quote a case, but I won't tell you which one, the Republicans say there is no penumbra of our privacy rights. There's just the right or there isn't. And it was wrong here to dismiss the case. So now what that means to you is the yin and the yang. You can set yourself up in arbitration. I'm going to show you how, so that you can be a real problem parker, but a legitimate problem parker, showing exactly why you should not go through this process. And then you can still go back to court and go, well, they ruled against me. And this the cool thing I'm going to show you, right? You're going to love this. And I told you about this, Judge, and I told the arbitrator this list of things that I was asking for my basic rights, and they went against that. So, whereas before the Supreme Court ruled in 2024, this year's rulings, courts just dismissed the case. Oh, arbitration, another one off my docket. It's a docket cleaner, right? Nothing to do with your rules or your rights. So that's a good decision for us. The other side of that, though, and I don't think this is a big deal, the yin and the yang is you don't automatically have a right to appeal the decision to compel you into arbitration, because as the case is stayed, the jurisdiction you're in, the judge you currently have, keeps the case. If he dismisses it, there's an order saying, case gone, you have an automatic right to appeal. You don't now. But I don't care. Rarely do you appeal people just aren't in that situation in some respects, at least on my level. So that's okay. I'll appeal when I need to. And what I'm about to tell you, the cool thing I'm about to tell you to do, sets up your appeal rights, sets you up nice. Because remember, the YouTube viewer asked, I've been forced into arbitration, what do I do? Here's another cool case. Morgan versus Sundance. And that was a case ruled on in 2022 by the same Supreme Court. And what was happening is let's say Citibank litigates the hell out of a case. You fight back because you got educated. Remember I talked about how they don't like you being educated and knowing your rights? And you start to, I've seen it, where you turn things around. The judge is like, hey, wait a minute. Ms. Smith is right. She does have a right to blah, blah, blah. When a litigant, a debt collector attorney or debt collection law firm sees that you're turning things around, they'll immediately file to compel arbitration if there's a contract. Most arbitration you're forced into is a result of you signed the credit card agreement by contract. They don't make an issue of that, and guess what? They sued you. They didn't automatically go into arbitration. They sued you. So then they litigate the hell out of the case. It goes through discovery. You start to fight back and start to win. They then file a motion maybe 6 months to a year later saying, court, they're supposed to go to arbitration. Commonly, courts would agree to that unless you showed prejudice. If you could show prejudice about having to go through all litigation, and after all that, now they want to start it all over again in a not so nice forum for you, unless you showed sufficient prejudice, you're going to arbitration after all that litigation. The Supreme Court said, we're Republican court. If it isn't written in the rule, we're not enforcing it. There's no rule that says the poor guy that doesn't want to go to arbitration, who just went through a 6 months to a year of litigation, has to show prejudice. No. The basis of that is when someone litigates a case, they are technically, and I've won on this issue, waiving the right to arbitration. You got two choices. You can arbitrate or you can litigate. There's great differences there, but if you choose one, you really can't have the other, right? If you're litigating, why do you now want to arbitrate 6 months later? So that's called a waiver. The waiver of your right to arbitration is allowed. If you can show a waiver, for example, they litigate the hell out of the case, I spent $7,500 doing all this work, courts are going to listen, I've won on those cases. I've won on those cases against Citibank. In fact, I will put on my video at my membership site the motion that I used to win against Citibank that was trying to get the case into arbitration after a year and a half of litigating the case. Suddenly I brought up securitization and started digging around asking for depositions. Immediately a motion to compel. That securitization stuff is powerful stuff. So now the court says you can waive your right to litigate a case in arbitration if you show that you litigated first. So I would argue every time someone sues you and then says, hey, we want to go to arbitration, you waived your right. Because they could have spent the same amount to send you into arbitration before they sued you. If they sued you, they automatically argue, waive the right to arbitration. That's a fair argument. So that is the case of Morgan versus Sundance. Now, the big thing that I need you to do and take from this video, the biggest thing, is to create a record of you complaining about having to go to arbitration. So in this person that contacted me, the YouTube viewer said, they forced me into arbitration. Now I got this letter from an arbitrator saying, hi, I'm your arbitrator. You're going through this process. You got to do this. You got to do this. She goes, what do I do? And I immediately said in my head, write your own letter. So what I'm going to attach this video to my membership site is a cool letter. And you're going to ask for discovery, the arbitrator's qualification. How has he or she ruled in the past for consumers? Where does he or she live compared to where you are now? Are they attorneys? Have they ever been judges? You want to know their feelings? No, you don't. You want to know legally how they handle securitization and the rules of assignment. Those are the bedrock of how you're going to get out of that debt. If you're going to be judged or arbitrated, you need to know that that person has ruled favorably for both sides and knows the law. So now you write this letter. Now I'm going to write this letter for you in Word template, asking for a ton of stuff that if it gets ignored and the ruling goes against you in arbitration, and specifically goes against you on things that you'd asked for, genuinely, you're going through an arbitration process. In some cases, they're making you pay money. You're right to ask about the thing you're paying for. There's no arbitration rule saying you can't. And you get killed on the thing you asked about. That's legitimate because the Supreme Court says the case still exists at court instead of dismissal. You go back to court and go, I got this ruling against me. I had asked you, and by the way, when you send this letter to the arbitrator, send it to the judge too. Make a record. So here's the cool thing. 99 times out of 100, you're going to lose if you try to appeal being forced into arbitration. It's a contract. They're going to claim you signed or you used the card, therefore you agreed to the contract. So you're going to lose. It's a breach of contract case. Now, because of this letter and this request, hell, create your own motion asking for all these things. Your Honor, we're heading for arbitration. Before we get there, I'd like answers from the other side for all these things. So take my letter, put it into your motion. In fact, write that as a condition. I'm going to use this expression. A condition precedent. Before you file that motion, give them a chance. Show your good faith. Go, hey, arbitrator, don't be a jerk about it. Can you give me all this stuff? I'll write the letter so it's a cool letter. You're just being a good consumer asking for all these things because the judge is going to have to rule your way or against you based on this stuff. Once you write that letter, it's either ignored or even if they respond and they do a half-ass attempt, Exhibit 2. Exhibit 1 is your letter. Exhibit 2, Judge, I just asked something very reasonable. They couldn't give me what I wanted. Then we went to court. Guess what? I asked, could you didn't know what I was talking about. That's not a fair process. And that's your motion to get out of the arbitration if there's a ruling against you. Or you may want to file it even when you're sent to arbitration because it's just been stayed. You could say motion to lift the stay to rule on this one motion. He or she will probably bat you back. But if you get a ruling against you in the arbitration, now you've got Exhibit 1, Exhibit 2, and you do a motion to overturn. You're probably going to lose, but you're not going to the Court of Appeals now with something you're going to lose 99 times out of 100. You're going now with your own created issue, which is, it's not fair, it's not due process. I first asked if you could please just provide me with the same rights that the United States Constitution grants me. So that's a cool letter. That's attached to this video. You're setting them up. I've talked to you before. Know your judge, right? If I'm in front of a judge and know he's going to gig me down the road, I will set her up with motions that she's going to agree to, that I know she's going to agree to, but she's not thinking down the road like I am. And then when she gets to that point where she gets to dismiss my case, I got her own writing going, you really can't do that. That's what you do. You're on your own. No one's your friend out there. I am. But set these up. Excuse me. I'll bleep that, Cindy. If they fail to answer your reasonable request, use it against them. If they don't have the rules to protect you on the very issue you're complaining about, you got another way to win this case, even if you lose at arbitration. So attached to this website will be that cool letter. Attached to this website. I'm not going to give you one. I'm going to give you two. I'm going to give you two responses to motion to compel. One is Citibank, and it's chock full of the Arbitration Act explanations for you so you can learn it. And also that Morgan versus Sundance case. And then I'm going to get a very recent argument against Discover Bank, seeking to put us into arbitration after they started litigating the case. And I believe the court dismissed the case. So I think the actual attorney knew this didn't go as well as they wanted, even though they won the motion. I haven't heard from them since. That happens, by the way. Sometimes they win a motion to compel arbitration. You've signed the contract. You never hear from them again. It just goes away. You just sit there. So attached to this video, what to do if you're stuck in arbitration would be that cool letter, 2 motions to compel arbitration responses, and my show notes, which set you up and explain things. It's a cool way to handle a bad situation and to make it your own. Take control. All my videos are about taking control. In some sense, you are using the documents against them again by setting them up, by sending this letter, going, can you make sure I have all these protections that everybody's allowed to have? And when they don't, you use that against them, right? So I hope that's helpful. That's an answer to the inquiry from my YouTube friend asking for help. And I hope it helps you. Like, love, subscribe, and keep rocking in the real world. Thank you. Set them up. Bye-bye.